community, contact them. To ensure no one project or community gets all the funds, there are 6 project categories.
We thank you for bringing us today to this very important committee meeting to consider the amendments to the Jamaica Constitution in leading us on the path to becoming a republic. We know that as we go through this particular committee and through the bill that is before us, there will be challenges. There are great expectations, and we trust that you will give us the wisdom, the guidance, so that as we proceed, we will come to the best result that is in the best interest of the people of Jamaica and Jamaica, land we love. Amen.
Amen. Do we have any apology for absence? All right. We move to item 4 on the agenda. We had a little break in our meetings. Let me welcome back members and the supporting technical team and those who are tuned in wherever you are. Interest in this matter of reforming the Independence Constitution continues to grow. I reiterate how unfortunate it is that a matter like this, which requires cooperation between government and opposition in order to have the bill to amend the Constitution passed before it is put for approval before the voting people of Jamaica. It is unfortunate that having proceeded in good faith on what we believed was consensus, we have spent so much state resources, time, money, and other resources to get the work going. And the parliamentary opposition reneged on the commitment it gave that there was consensus for us to move forward. Yesterday, I reported to the Honorable House on the work of the Ministry of Legal and Constitutional Affairs for the last legislative year, which coincides with the financial year March 1, 2024, April 1, 2024 to March 31, 2025. I reported on the progress that we have made in this very important work. And since memories are short, I also reminded everyone that contrary to the impression being given in some places, when we proceeded, we did so taking the opposition leader to his word that although there were other things to be done on which consensus had not yet been reached and which cannot be forced, we would proceed with the matters on which we have consensus. This country remains work in progress. We talk a good talk, we identify the problems, we discuss the problems ad nauseum, and we have fallen short at implementing workable solutions or moving from problems to solutions. The goal to transition Jamaica from a monarchy to a republic was set a long time ago, because the process is fixed constitutionally. Successive administrations have not risked the political capital to proceed with the work. Prime Minister Holness, in good faith and in response to yearly call from all quarters of the society, including from the current leader of the opposition, assigned the work to abolish the monarchy to be done. And here we are, without the necessary cooperation from the opposition, because they wanted included in the process matters that remain work in progress, because we have not yet arrived at consensus. Ladies and gentlemen, colleague members of the committee, we can't afford to exercise leadership in this way. And the people of Jamaica will judge. When those who are seeking leadership in government say something, we should be able to take them at their word. Having said that, I believe that we have gained much in the process so far. What we have learned has enabled us to correct a lot of inaccuracies, some of which are written in textbooks and are taught in the universities. And the good thing is that we have real-time verbatim records. So it's not Marlene Malahoo Fort saying so. The records are there to show. I still remain excited, though I know that we are limited in how much we can achieve for the remainder of the life of this Parliament. But what the work has done is further open our eyes to the kind of responsiveness, the kinds of reforms, and the kind of responsibility that must come from government. And I remain grateful for every one of you who has made your voice heard, whether in frustration or otherwise. You have contributed to the work, because I know certainly at the Ministry of Legal and Constitutional Affairs, which has portfolio responsibility for this matter, we have learned so much, and we are honing our skills. I said yesterday in my presentation that it requires sound technical competence, specialized skills to translate recommendations and desires into sound constitutional principles and sound legal policy. And that doesn't happen by mere talk or empty rhetoric. So we're learning. We're learning a lot. I want to thank the members of the committee who have shown up, because I know not all members have. I recognize that we are in a challenging context, but the work of government must go on. And the work of government is about serving the interests of the people of Jamaica. So these are my opening comments. As I usually do, I allow members, if they want to respond to anything I say, to do so briefly. If either Member Sinclair or Member Golding Charles has anything to say in response to my opening remarks, it will be permitted. And then we go to the confirmation of the minutes, matters arising, and then we begin on the item which continues our review of the matrix of submissions on the bill. Any hand is up?
I have nothing to add. Madam Chair, I think you have captured quite a bit of the sentiment that I would have expressed myself. I would have expressed myself, and I know that the Jamaican people are looking on, and they expect the best outcome. When we look on the general sentiment coming out in polls, that there has been an increased desire for us to move to the stage where we become a republic. And as you have said, there are other issues, and I do agree with you, because it impacts not only Jamaicans, but other persons from outside who would want to invest in Jamaica, that they look on the structures that we have, and based on that, including our judicial system, and it is on many aspects of things that they ultimately make their decisions. And the Jamaica, for where we are as an emerging economy, one that is seeking to gain prosperity for all, we depend a lot on foreign investment. So those are there are factors that investors take into account, as I said, including our court systems. So we have to tread carefully, and we have to look on all the options that are open to us. And there are several persons have put forward, whether we have the Privy Council, the CCJ, or whether we have a homegrown appeal system where we have our final appellate court here. So there are different views, and all have to contend and give them great consideration.
Thank you.
And that, as I said, I expect that we will in fact arrive at the best decision in the best interest of our people.
Thank you, Member Sinclair. I know sometimes that there are challenges with the connectivity. As far as possible, I ask when members are intervening to come on camera. As you know, we televise the proceedings of Parliament and its committees live to the people. I suspect
Yes,
you may
Chair,
have been having challenges, yes.
Yes, I did actually open the video on my system, but I realized that I have not seen. Normally, I would see myself looking on my screen, but I haven't seen it. So
check if your camera window is closed, because sometimes that happens.
Oh, okay. I see. I will check that. Thank you.
Yes. All right. Just to reiterate to everyone that the policy of the Jamaica Labour Party and of this Wholeness administration in respect of the judicature branch of government is to not just look at the final court as we reform the Constitution, but to look at the administration of justice. And in making a decision as to which final court is best for Jamaicans, we are mindful that Jamaicans themselves have said that there are 3 options to be considered, in no particular order: retention of appeals to the Privy Council. In that context, it would not be the Majesty's Court. It would be a court chosen by Jamaica, and the advice would be given to the Jamaican people, not to the monarch. There is also accession to the appellate jurisdiction of the Caribbean Court of Justice. The Caribbean Court of Justice is already a court in the Jamaican system, though it is not a domestic court, meaning that it does not deal with national issues. It deals with matters related to Jamaica's membership in the Caribbean community, CARICOM. And then the third option that we are asked to consider is whether to establish a Jamaican final court. We will have to look at these options. The arguments in favor of some may be stronger than others, but process is just as important as outcome. And when we are making these kinds of fundamental changes, it is also important that people take ownership of the institutions. They take ownership of the work and the outcome. So that is where the Jamaica Labour Party parts company with the PNP opposition. For us, it's not just a show in going through a reform process. It's to ensure that we truly come out substantially better, not just in form better, but in substance better. With that said, I don't see any hands raised. We go to item 5 on the agenda, confirmation of the minutes of the meeting held on Wednesday, April 2, 2025. Just before we go, the records would show that on at least 2 other occasions we had convened but did not have a meeting because we did not have a quorum. Right. I think that is also, that should also be included in the records. It could be put in today's records of today's meetings. So we just fill in the dates, right, just to remind everyone for the record. All right, so the minutes are before us. The first page sets out attendance. If there is no correction, we can go to page 2. If there is no correction to page 2, we go to page 3. If there is no correction to page 3, we go to page 4. On page 4, in the last paragraph, the second sentence in the third line, it should be corrected to read, who would not be appointed on the recommendations of the leader, the Prime Minister, or the leader of the opposition. So we replace the word by with on the recommendations of. And there is a letter N in the 5th line that seemed to have just been an editing slip, right? If there is no other proposed amendment to page 4, we go to page 5. If there is no amendment to page 5, we go to page 6. I'm proposing that the word though in the first line be deleted and replaced with and in accordance. The words though under be deleted and replaced with and in accordance with. So the sentence, the relevant part of the sentence would say, the chief policy-making body and in accordance with Section 69 of the Constitution was collectively responsible to Parliament for the policies made. So you delete it and then you add for the policies made. All right, if there is no amendment, other amendment to 6, we can go to page 7.
Chair,
Yes?
the final paragraph on page 7, beginning with Member Charles,
Yes.
I believe who should be inserted between only and persons.
And it's really Member Sinclair.
Yes,
Yes.
that was going to be my correction,
Yes.
Madam Chair.
Please repeat, Mr. Harper.
The final paragraph with the opening Member Charles, a who should be inserted between only and persons in that first sentence. Not only 2 persons who were to be elected or appointed to Parliament.
Applicable not only 2. So we
Right.
insert 2. Yes. All right. If there is no other correction, then we note and go to page 8.
Um,
Yes?
Chair, I'm not sure, but that paragraph right above where clause 20, the reference to clause 20 when Mrs. Paris Campbell read that,
Yes.
that paragraph, that first line, the chairman then reviewed that when the matter of citizenship and the Commonwealth was being discussed in the Constitutional Reform Committee, should that be citizenship of or in the Commonwealth? I read it again and something just seemed a little off there. Because I think the point you were making was you were talking about the question of Commonwealth citizens
When the, yes, when the matter
arising
of
out of the colonial.
Commonwealth citizenship. It's more
yes,
broadly
that's better
the
said.
issue of citizenship in relation to the Commonwealth. But it was really, so technically
Sure, you
speaking.
just said it, you just said it.
No,
that word you use, Commonwealth citizenship,
yes.
would make it clearer for me.
Yes. No, what I was about to say, Member Golding Campbell, is that we were discussing both the issue of citizenship and the issue of the Commonwealth. And when both of those matters were being discussed, we had spent some time examining the treatment of current parliamentarians with citizenships in other countries. So the issue of citizenship separately, the issue of the Commonwealth and the treatment of the Commonwealth also. But I understand your point that set as is, it is ambiguous. Right, so it could also be clarified by pluralizing matter to when the matters of citizenship.
That clears it for me as well. Either or.
All right, if there is no other correction to page 8, we note the proposed corrections and go to page 9.
Clear?
Yes?
On page 9, the reference there to Miss Wilkins in the final paragraph, it alternates between MISS and MS. I think for consistency, one should be used, and also not to jump ahead, but Miss Wilkins is further referred to about page 11 and introduced by full name and title at that point. So I believe because there's a reference to Miss Wilkins on page 9, that might be the better place to introduce her by full name and title, and anything to come thereafter can just be Miss Wilkins.
We're all agreed on that. There is a little rule around that. If you are going to abbreviate, you set out fully what is being abbreviated at the earliest opportunity, and you indicate in parentheses what the abbreviated form will take, and then you proceed with that. Thank you. MS. All right, I am proposing amendments to the penultimate paragraph on page 9, which commences the chairman. In the second line, just change disqualifying factors to criteria. Yes, so, yes. Delete the word factors and replace it with the word criteria. And in the second sentence, which has multiple clauses, at line 6, I want, the sentence would say, she explained that an 18-month sentence, I'm asking that it to be corrected to read as follows. She explained that an 18-month sentence was taken as an indication of the court's view on the gravity of the offense for which the sentence was passed. All right.
Chair, can I ask you to reread that? I'm so sorry.
Right.
I think I got a little lost.
She explained that an 18-month sentence was taken as an indication of the court's view on the gravity of the offense. So,
okay.
Right. Because
Got
an
you.
offense
Thank you.
can be committed, the same offense can be committed in different circumstances. And the circumstance can reflect a minor infraction, but it meets the example, like murder. Murder can be committed under outrageous and just heinous circumstances. And it can also be committed in circumstances that are viewed a little differently. It's just that. So sentences are supposed to be proportionate. And that was the point. But there is something else that we have to come back to with this point. All right, if there is no other correction to page 9, we note the proposed correction and go to page 10. All right, in respect of page 10, I am proposing that the word background in the penultimate line of the second paragraph be deleted and replaced with antecedents. And that in the following paragraph, that the word why be inserted between understanding and the offense. And after offense, the words was committed be added. So the corrected sentence would read, though the act was legally theft, the circumstances surrounding it would be significant in understanding why the offense was committed. If there is no other correction proposed for page 10, we go to page 11. If there is no correction for page 11, we go to page 12. If there is no correction to page 12, we go to page 13. Although I would ask members to help me, it's not really taught ideas not grounded in official records. Ideas is not quite the word, and I don't want to say things, but it's really what they were taught are not verified by the record. All right.
Concepts.
Concepts, yeah, that could. But the example that came to mind was around the Constitution, a view that the Constitution was not made in Jamaica. Notions, yes. All right, so as corrected, we go to 13. All right, I am proposing that the word elected be changed to selected in the second paragraph, line 1, 2, 3, 4, 5, 6, 7, 8. So we're talking about the selection of a president, not the election of a president, just to avoid confusion. All right, and the selection process is a two-stage process of nomination and confirmation, even though the confirmation involves a vote among parliamentarians. Sorry? Yes. And then it would follow from the first use of selection. I understood why you put elected, or it may have been said. All right, if there is no other correction proposed, we go to page 14. If there is no amendment to page 14, we go to page 15.
Good afternoon, Chair.
Yes, Ms. Mills?
I am seeing where we abbreviated Jamaicans for Justice on page 11 as JFJ,
Yes.
but on page 14 in the second paragraph, we have JFJ, and in the third paragraph, we stated Jamaicans for Justice.
All right.
I think my suggestion is to abbreviate it in the third paragraph.
Well, thank you, Ms. Mills. We have indicated that in every document, the first mention of any word or term to be abbreviated should be set out fully, and then the abbreviations come in subsequent references as a general rule. So I ask the committee clerk to bear that in mind going forward. And any other matter to be corrected for that reason would be treated accordingly. All right, any correction to page 15? I'm just going to be asking for a rewording of that second paragraph. Ultimately, Chairman emphasized that what mattered was that the process did not end simply with the Prime Minister being empowered to nominate a candidate. Rather, what was crucial was the confirmation process that followed. That's the part I want to read. A process that represented a transitional compromise. I don't think that quite captures it. Yes. Right, so that sentence that can be taken, that, right, the arrangement was designed to give elected representatives, along with those, the authority to confirm the nomination on behalf of the state. Yes, so that paragraph, that sentence can be deleted. The one commencing rather. Mm-hmm. Right. There is no other correction. We go to page 16. And for those watching, if you're watching, it may seem a little boring that nothing is going on, but you know, accuracy matters, and we have to faithfully go through the records of the deliberation as reduced in the minutes, so that they become part of the historical records for people to check. So bear with us if you're watching and nothing is happening. Something is happening. It's just wouldn't be exciting your attention. Any correction to page 16? I'm just proposing that the word either in paragraph 3 be changed by both, because there are other ways by which citizenship may be acquired. It's not binary. All right? Right, just put or by birth, yes, or just delete either. We go to page 17. If there is no correction to page 17, we go to page 18. All right, if there is no correction to page 18, will someone move for confirmation of the minutes as corrected?
I so move, Madam Chair.
Thank you. Seconded?
Seconded, Chair.
Thank you. Matters arising. All right, there is a matter that may not be reflected. Madam Clerk, I'd asked on a previous occasion that the corrected minutes be forwarded to all of us. At the Ministry of Legal and Constitutional Affairs, we also post the records of the meeting. I know primarily the Parliamentary website would be the place for this, but there can be more than one places where it is done. So if you have forgotten, just a little reminder. Right, but may I suggest a little strategy? I call time and a half shorter than 2 times. So since you are here and the electronic version of the minutes would be right before you on the screen, just pull it up and do it at the same time. You can always track the change to note. Right, we have to be present where we are in the moment. Time and a half is shorter than 2 times. I'm not going to ask again because we would like to post all of the minutes of the meetings, right? Thank you. Matters arising. The last page of the minutes showed the ask for the list of issues requiring policy considerations to be made. I'm just checking in with the ministry team whether that was done. Mr. Cross, collaborating with the clerk, all right. Madam Clerk, committee clerk is saying that it was done. And thank you. That is very much here in hard copy and soft copy. May I ask that the hard copies be set aside for the senators for Friday? All right. So all right. So we have the list of policy issues for refinement and consideration, and just to indicate that in the regular way for issues of policy to be dealt with, we will at the ministry, in collaboration with any other ministry that has subject matter responsibility for the issue, go through and see how we can address those issues. They would have to go back to the cabinet for approval. So just by way of reminder, when a policy issue arises in the Parliament, properly speaking, that issue should be stated with clarity. It should be considered by the minister with the responsibility for the subject matter in the ministry, and then placed before the cabinet for a decision, and then the cabinet comes back and account to the Parliament for that policy decision. And policy, of course, can always be informed by input from anyone. But it's important, coming out of this process, that everyone becomes clear on the lawmaking process and the policy-making process and what the Constitution says. And we have to get to the place where, when we pass laws, the laws that operate in practice are the laws that are on the books. Because you have laws on the books and the law in operation is a completely different thing. And a double-minded man is going to be unstable in all his ways. All right. But in addition to that, colleague members, just to say that we have been discussing the issues and we have been expressing views and leanings, but we have many issues that the committee will have to make a recommendation on. The decision of the committee and what the recommendation is. So I have asked the committee clerk to start preparing the report, and then we can leave the sections of the report for decisions to be finalized after we conclude the review of the submissions set out in the matrix. All right, so we're going to now move. Is there any matter arising that members wish to address?
Madam Chair. Sorry, go ahead.
Sorry. Not from my perspective. The issues that are awaiting policy consideration is primary to me. Yeah.
Thank you, Member Sinclair. Member Golding Campbell?
Yes, Chair. I think the minutes does reflect that I had asked if the committee clerk could just give us an updated list of all the submissions. I just want to make sure that I have all that I should have and that I'm aware of all who have submitted to the committee.
I am advised.
I don't know if she has, but
I'm
I haven't seen
advised, Member Golding Campbell, that the version of the matrix that was emailed last and which we have the physical copy here in the House and which will be sent up to the Senate for Senate members on Friday, that this is updated to present with all submissions received from all places.
Okay, very well.
Yes. And it was emailed. And it's a bulky document. I find it may be more helpful to have the physical copy. Yes.
Yes, I tend to prefer the physical copy.
It's wide screen too. Yeah. All right. There.
Also, in the email that we received yesterday, the list of submissions is included as a document by itself.
Thank you. Thank you, Counsel.
Thank you for that, Parliamentary Counsel. The committee clerk has printed that list also right here. So I'm very pleased that all of the matters arising from the minutes were reasonably foreseeable and have been addressed. No, that's a good example of what efficiency can look like. All right. You know, yesterday when I was reporting, I told the House and the public that at the Ministry we have been constantly innovating and streamlining, just looking at how we can utilize time a little better. And this is an example of it. You know, you go through and you know what's going to come up. Once you read it, you have to do the work. And you do the work, it lifts all of us. All right. So let the records show that as at May 7, 17 persons and or groups have submitted to the committee. The Akompong Maroons, the Church of Haile Selassie I, Equality for All Foundation, Jamaica Limited, the Faculty of Law, University of the West Indies, Mona, the Jamaican Bar Association, the Jamaica Coalition for a Healthy Society, Jamaica lands, and I ask that lands always be set out. Left Alliance for National something. Yes, but we have to set it out, so it's set out in the minutes. Left Alliance for National Democracy and Socialism. But right here now, we now go there, you know. We now go to socialism, because what we see is that it has not yet worked, contains so many enticing ideals. But that's the comment of the chair, personal to the chair, and in fact, my personal views. All right. Although some say that in essence, we're kind of a socialist country, regardless of which party is in power. The Jamaican hummingbird Taino people, Jamaicans for Justice, the Ministry of National Security, Mr. Christopher Pinge, Mr. Hugh Dunbar, Mr. O'Shane Wright, Ms. Helene Wilkinson, the Rastafarian Unity Council, Inity, pronunciation varies, the Rastafarian Mansions and Organizations, and the West Indian Tribal Society. So just to say, I'm discovering from this list the different Rastafarian societies. So the Church of Haile Selassie, I don't know how they relate to the Rastafarian Unity Council and the Rastafarian Mansions and Organizations. But we note 17 entities, persons or groups have made submissions, all right? Okay. Where is my copy of the minutes? The other matter, right, members, I'm looking on page 6 of the minutes in respect of the wording of the provision about the appointment of independent senators. I believe that we had made a decision to recommend that the provision be reworded and that the groups taken out, referenced in it be taken out, and that it would generally read from persons who are competent and capable of making the decisions in a more broader way. Members? Yes?
Yes, Chair, we're recalling that.
Right, okay. So I just want it to be reflected as a decision and for the Office of the Parliamentary Counsel to come back with a proposal as to how what we're seeking to achieve can be captured in a draft. All right. So I'm listing the wording of the provision for the appointment of independent senators. The other matter I have seen, which is raised somewhat tangentially, is the matter of the participation, the votes, how the votes in the Senate is to be, the votes in the Senate are to be taken on matters, provisions that require a 2/3 vote outside of the amendment, the 49 mechanism. No, I have read and heard the leader of the opposition repeatedly said that the proposed amendments to the Constitution are removing the safeguard of the requirement of a vote from the parliamentary opposition for the entrenched and deeply entrenched matters. It is not true. And I use this medium to ask the leader of the opposition, Mr. Mark Golding, to be a little more responsible in how he communicates his concerns. Because he is a trained attorney at law and people are taking cues from him. Among the many reasons for having this joint select committee is to allow for us to review the bill, to see if there is anything that was unintentionally missed, to see if the draft as provided reflects the policy intent and ultimately the intention of Parliament. This nation needs responsible exercise of leadership where genuine concerns can be addressed in the appropriate forum. I know we are in the politicking season, but you don't get to lead government if you don't get to the parliament. And if you're in the parliament and you're not being responsible, that's a clear sign that something is very wrong when you're seeking the leadership of the government. Right? The formula proposed retains the requirement for at least one vote from the parliamentary opposition. The maturity to handle these issues is missing in the opposition because we're not talking about opposition as currently constituted or government as currently constituted. It's anyone in a system where you, in a majority rule system, which is what the democracy is. Now, we identified from very early that we may have to make an adjustment to a provision in the Charter chapter at section 20, because in that section, there is also a requirement for a 2/3 vote. But because the leader of the opposition had made so much fuss about the Charter, when I stated that we may need to tidy up the language of the Charter, he immediately escalated it up to states of emergency quarrels and got into temper. You can't make sound decisions when you're so emotional and ill-tempered. So we recognize that the proposed amendment to section 49 was primarily geared at a less cumbersome system alteration mechanism, and that we would have to make some adjustments to any provision outside of the constitutional alteration where a 2/3 vote is required. But it is so untruthful to say that what is proposed is disturbing what we now accept to be the role of the Senate in Jamaica, because that's not the role in other countries. But That's what our constitutional convention constitutional provision, not just convention, explicit constitutional provision mandates. We have to have steady head for leadership, no matter how the storm rages around us. You can't allow the confusion in the space to start confusing the minds of those who are seeking out high leadership. And so I'm asking, do not mislead the people of Jamaica about what is contained in this bill. If you were responsible, you would be right here making suggestions, using the cranial capacity to improve on what we have. Because brilliance does not reside in any single place, nor does wisdom. Collectively, we can work together in the interest of the nation. Having said that, just to say to members that under Section 20, the resolution to extend a period of public emergency or public disaster beyond the initial 14 months requires a 2/3 majority vote. And we will have to consider how that would be dealt with in the context of the expansion of the Senate. The mechanism that is in place can apply, and we have the same effect. It's just that we didn't have a reference to the section. So we looked at it. It's just a reference in correction that would be required. No, I'm being told that I said 14 months. It's 14 days. Yes. Please correct that. Thank you. 14 days, not months. All right. That's the other matter arising. So that's Section 20, 2/3 vote, and the new Senate arrangement. Just checking, maybe I'll just open it up for input of members. So since the last review of the matrix, we had gone up to clause 20 of the bill. We had done clauses 15, 16, 17, 18, 19, 20, and we ended at clause 20. That's what my notes show. Additional submissions have come in with comments on those. We are closing off the submissions, you know, we can't take them back. Oh, sorry? Yes. So, ladies and gentlemen, this work is going to continue in the life of the next Parliament. So it's not coming to an end. But for now, we have to close off the submissions, the receipt of submissions. All right, it can't be kept open-ended, so please take note of that. So we were up to clause 20 last time, and then we will have to go back to see the additional comments that have come on the clauses that were previously considered. So I'm inviting members to go to clause 21, the amendment of section 41 of the Constitution. And we really have no comments on that, I believe. Just checking, right. Because that proposed amendment, clause 21, is dealing with our replacement of the word Commonwealth with a Jamaican. That's the citizenship matter. All right, so it's understandable. So we move to clause 22, which is dealing with the alteration of the Constitution. '22. Ms. Wilkins, you want to take us through? You have to update it.
Repeal and replacement of section 49 of the Constitution.
Yes.
Mona Law School recommended that, increase campaigning and public education are needed to enhance voter turnout during constitutional referenda. Instead of a 14-day period, a mandatory period of 1 month, followed by another month, should be required before amendments take effect. As it relates to clause 22.
Hold on there now.
Sorry.
That submission came from where?
Mona Law School.
We are not proposing any 14 days for anything that requires a referendum. Currently, there is no waiting time period between the tabling and the debate and voting on a bill in the House that seeks to amend the ordinary provisions of the Constitution for which an absolute majority of votes is required. So I'm not sure what provision is read or understood.
I'm thinking it's 49(1)(a) that refers to a period of 14 days. It says, a bill for an act of parliament that alters any provision of this Constitution other than a provision specified in subsection 2 or 3 shall not be submitted to the President for assent unless a period of 14 days has elapsed between the introduction of the bill in the House of Representatives and the commencement of the first debate on the whole text of that bill in the House, and a further period of 14 days has elapsed between the conclusion of that debate and the passage of the bill by that House. I believe that that is the provision that they are commenting on.
And the comment is that for matters requiring a referendum?
Instead of a 14-day period, a mandatory period of 1 month followed by another month should be required before the amendments take effect.
You know, it's interesting that currently there is no waiting period.
No, there isn't.
Right. And we know we have had issues around bills being tabled and taken through all of their stages in 1 day. This proposed amendment is to prohibit that and to allow for members of the Parliament to read the bill and, if need be, research and explain. Sometimes there are simple amendments, but the Constitution as the supreme law has to be treated in a different way. And the need to take a bill through all of its stages can arise out of necessity. Nothing that is ill-intended, nothing that would go to maladministration. So we have to kind of strike a balance. The 2 weeks is a sufficient balance. You know, we just want to take a whole lot of time. Already we have the 3 months for the other provisions. But let me hear, members of the committee, it doesn't find favor with me, I can say, up front, because that's a minimum time, it's not a maximum time. Members Sinclair and Golding Campbell.
Madam Chair, I was distracted a moment. Can you just go repeat for me, please?
Senator, it is a comment from the Mona Law School on clause 22, which is amending section 49 by introducing as section 1A a provision that before a bill is submitted to the President for assent, a period of 14 days should elapse between the introduction of the bill in the House of Representatives and the commencement of the first debate on the whole text of the bill. And a further period of 14 days should elapse between the conclusion of the debate and the passage of the bill by that House. So the Mona Law School is instead proposing that the 14-day period should instead be a period of 1 month, followed by another period of 1 month before the amendments take effect.
I don't know which school is the Mona Law School, but it's the Faculty of Law of the Mona campus of the UWI. Okay.
I think it's the Faculty of Law. I'm just reading what's in the document, but I believe it is intended to be the Faculty of Law.
And that provision is relating to just ordinary bills, Madam Chair. That's why I understand
the
that
non-entrenched provisions of the Constitution, what we call the ordinary provisions. So by way of reminder, the provisions of the Constitution fall into 3 categories, and they are by virtue of what is required to amend them. So those provisions that are given the highest level of protection require ultimately the approval of the people. That's a referendum, the deeply entrenched provisions. Yes. Then the entrenched, which require the 2/3 vote and the waiting period. And then the ordinary provisions, which only require the majority of all members of each house. And this is in contrast to the majority of the members present and voting when a sitting has a quorum.
Yeah. Right. And they are asking for it to be a longer period of time.
A longer period. Currently, there is no period.
Yes, right.
But we're putting in a 2-week period as a minimum.
2 weeks.
Right.
Well, it seems to be more than it's a month.
Right. So it's a month in total. 2 weeks and 14 days and 40 days.
Yeah.
Right. And those are minimum period.
Yeah.
But we have to bear in mind that going forward, we will want to do things in a more time-efficient way. And, you know, we have a finite time in a legislative year, and we have periods that are set aside for the budget process, for the sectoral debate, for the state of the constituency debate. So as we go forward, we have to design our rules that will be both time-efficient and not compromise the quality of the work that is coming before the Parliament.
Yes.
careful consideration was given to the time period, and I think because it's a minimum, it doesn't mean that in appropriate cases.
It
Well,
could
let
not
me
be
see if it
longer
is,
than.
maybe it's just worded as at least, or that a period. Let me just look to see how it is worded.
On page 28, Minister.
Yes. All right, so let's see how the other, not less than 2 months nor more than 3, that a period of 2 months has elapsed. But even though it doesn't say
It's
so,
similar
that is
to,
how it would be interpreted. Because if you were to go under that period, then you would be in breach.
Right, but you
yes,
Right.
over.
Yes, but you can. It can be longer, but not shorter.
it
Right.
can't be less than.
Right. That's how it would have to read without leading to an absurdity.
Okay.
Yes, there are rules of statutory construction. So what if on the 15th day disaster strike and you can't have a sitting? Just means you can't go under that time.
Okay.
And that is really how the others have been interpreted, that period. But let me just say that I'm not dismissing the reason for the ask, because we really must get to the stage where when bills come before the House, they can, the wider public can be brought in and made aware. In fact, I dream of a time when the parliamentarians will take the bills to their constituencies and have robust engagement on it. And what we are working on making available to the public via the Jamaica Legal Information Portal will allow members of the public to input a suggestion on a bill or anything being reformed. I'm really excited about what is coming. And I know others share that excitement, right, Ms. Wilkin?
Most definitely, Minister.
Yes. All right. Next. So members online, you share the view that this recommendation would not be accepted? Yes.
I'm with
all
the
right.
Minister.
Next.
They also proposed that as it relates to the entire Clause 22, the existing structure should be rewritten for clarity and accessibility.
No, that finds favor with me. You know, we've been trying. It's really hard, and I commend the Chief Parliamentary Counsel, but we can improve on it. It's true that the Section 49 mechanism is complex. So the faculty, if reps are listening, you can take heart that we hear the view that we have to find a less complex way to set out the alteration mechanism without compromising what it is designed to protect. It is calling for very deliberate consideration of the provisions that are so protected. Yeah?
Jamaica lands, we would like clarity on whether changing from a supermajority vote to a majority vote for electing the president undermines the goal that the supermajority vote was intended to achieve in the first place.
My view is that deliberations got into some crosshairs because some were in favor of a transition to the executive presidential system as initially commended by Carl Stone, and still is not out. Part of the work that has taken place since then is that we have sought to untangle or detangle the crosshairs of the executive presidential system from the parliamentary cabinet system. It remains work in progress because a lot of people don't understand how features of one system may creep into your system, and you don't have the supporting norms and institutions, and then you result in problems, because every law that you pass must be implemented and enforced, and government must be enforced. And what I'm trying to avoid is the mistakes of the past, where things sound so nice and we legislate in such convoluted way. We don't have the democratic norms. We don't have the social institutions to support. And our practice is at variance to what we legislate. We can't go back there. The other lesson that we are learning in the time gap between recommendations and implementations and the revisions of those recommendations is that, I lost my thought, but it's that you just have to take care. The point is that we don't want any confusion as to who is ultimately in charge of the running of government, the day-to-day running of government. So we're not sending any mixed signal that a non-executive head of state should be descending into the day-to-day running of government. We don't want any mixed signals about that. And we have seen where it has happened in some places. With all of our challenges and all of the needs for reform, we have still enjoyed a level of stability in our democracy, even when other things are dysfunctional, that enable us to go forward. And we don't want to risk that. Now, having said that, it don't mean that we mustn't bust up some of the systems and practices. I'm all in favor of that. But we have to counter the cost. And we have to be clear about what we're prepared to afford and what we can't afford at this time. So, in answer to Lance, and the clarity you're seeking is that the change to the absolute majority for the confirmation of the president does not undermine the goal of having the representatives of the people elected and appointed after general election confirm the person who would sit symbolically as our head of state. It does not at all. We don't want anybody getting any mixed ideas that they get elected in a certain way, and so they can pull a coup or they can take over the running of government. Lord knows that we have to become more orderly, not less orderly. Be clearer, not more confused going forward. So again, I believe, even though I do not see the records setting it out that way, that maybe it was just a compromise between the two factions, of one side wanting the presidential system, the other side wanting fears about how we're going to transform and transition. Now we're a lot clearer of the differences between the executive presidential system, the parliamentary cabinet system. We know that the Westminster style is but one example of the parliamentary cabinet system, and it is the one that shapes ours, but we still don't have all the features of it. But there are other places that never experienced colonialism, never experienced British rule, that have the parliamentary cabinet system. What we want to get to a stage is where the kind of accountability that is inbuilt in the cabinet parliamentary system actually takes place. Because if the fear is about autocracy and concentration of power, the executive presidential system leans towards that. No, it is true that in practice you may have the parliamentary cabinet system displaying those features by over-deference being given to a prime minister in office. And I know that there are concerns about that, and I'm not speaking about any current prime minister. We're talking about prime ministership in Jamaica. And it is something that we will seriously have to look at, because no leader and no holder of office is helped where there is deference and not a holding to account. I mean, you don't want people standing in the way and become obstructive, but you want to be held to proper account. Good check, good balance. All right?
Okay.
So we're not going to formally convey that explanation to Lance, if you are listening. As we would say to anyone who has made submission, pay attention to the proceedings. You can also access the minutes to see how your particular issue was addressed. Maybe at some other stage we will have the capacity to then respond to you individually in the same way that you have submitted. That is work in progress.
The Jamaicans for Justice, recommendation 1. It is recommended to include joint select committee and public deliberations to alter provisions of section 49(2) and 3. Legislative proposal include recommendation to refer any bill amending subsections 2 and 3 to a joint select committee. And they have a proposed draft. Any bill or act of parliament that seeks to alter any provision in subsections 2 and 3 must go to a select committee in keeping with the standing orders. 2, requirement under subsection 1 may be waived by at least 2/3 vote in both houses of parliament. Another proposal.
Just to say that law in Jamaica is not just defined as a written law, you know. There are many things that have the force of law. And the conventions around practices should. I know we're not yet there in how the parliament should work, but I so have faith that we will get there. And I also know that faith without works is dead. So the work side is coming. All right, we are still a young nation, work in progress. I don't know that it should be mandated in the Constitution that a matter be referred to a select committee or a joint select committee. But what I believe to be good practice is that, especially new bills, that they can benefit from review in a committee system. In fact, the strength of the parliamentary system is a committee system. We are going to, in the next parliament, look very seriously at that. And that's how you get participation of backbenchers in a real exciting way as we deal with the business of the people. So I'm excited about what we are looking to achieve in the next parliament, and is why we say stay with us, because we're very clear after listening to the people and taking note of your concerns where we need to move our country to and how our institutions operate, and in particular the primary institution of the parliament.
Another proposal. This is the relation.
So just to also say to Jamaicans for Justice that the practice of inviting submissions from members of the public achieve the goal of the participation of non-parliamentarians and members of the public in the work of the Joint Select Committee reviewing a bill. I know everybody wants their own turf and they want their own place, but we can achieve the same goal in different ways. So let us be clear about what we're seeking to achieve. We're seeking to achieve input from the people directly, or through their representatives, with a view to improving anything that will impact their lives. So we don't have to, there's no one form, but whatever form we agree on should allow for efficiency in getting the results.
In relation to public deliberation, there's another proposal. The proposal is at least 30 days before a bill amending Section 49, subsection 2 and 3 of the Constitution is introduced in either House of Parliament, the person or committee intending to introduce the bill must publish in the Gazette and in accordance with the standing orders particulars of the proposed amendment for public comment.
All right, just to say that right now, Section 49 can only be modified, altered, with the holding of a referendum. I mean, the approval of the people. It can only be done. It is not the intention to be regularly amending Section 49 going forward at all. So that has to be clear. Section 49, I think it was former Prime Minister Bruce Golding who described it as a tight belt around the waist of Parliament. This proposal, we are seeking to loosen the belt without compromising the rail guards. So what you are asking to be achieved, you'd have had all the time since the bill was tabled on December 10, 2024 until now, because the bill went public that very day. So you would know it, know where to find it, and have time to deliberate on it. Before a referendum is held, the bill will be published in the public places as we decide, to ensure that those who will vote on it will do so in an informed way. And that's why there is a minimum of 2 and a maximum of 6 time frame between the passing of the bill in both houses before it goes to the people for their approval, to ensure that the necessary arrangements are in place, the necessary public education and public awareness is done. But a year, is a long time. I know, because we have taken so long to do so many things. Every year we have a budget pass. Some are appropriated for specific things. And the Parliament comes in legislative year. So we're seeking to make better and be more efficient going forward. So just note that whatever you're asking for now, you have ample time for it to be achieved. And we will take on the suggestion that we can probably separate the clause and blast it out in big prints. Bear in mind, though, that people are more utilizing the digital form. And we print a lot of things that we have to turn around and collect because people don't come and take them up. They want to have it in their palm, in the palm of their hands, wherever they are, without the additional bundles and books. But I am highly persuaded by the ask or the recommendation about finding a simpler structure for the alteration provision. And I think time will allow us to do that. All right.
There's actually another aspect to the proposal. The person or committee introducing the bill must submit any written comments received from the public via a compiled report to the Speaker for tabling in the House of Representatives at least 30 days prior to the commencement of debate on the bill. And that requirement may be waived by at least 2/3 votes in both houses of Parliament.
Actually, what I would like, what immediately came to mind, and again, going back to form, everyone in Jamaica lives in a constituency. And if you are a registered voter, you have a member of Parliament. All right? You may. So I would like to see citizens make their submissions to their members of Parliament, and that we find a way to ensure that members of parliament actually bring to the debates what their constituents have informed them about. Because the way the lawmaking process goes is that the bill is tabled, the bill is read, and I must confess that I have been thinking about the way in which we read the bill. Because just saying that the bill is read a first time doesn't mean that the content is read. You know, that's an abbreviated form. And sometimes bills are passed and the parliamentarians have not read the content. That's why we struggle with implementing the laws. If you ever know the level of ignorance that exists in the society, people have powers they don't know, those powers even within government. And that's why the JLIP portal, when it becomes operational, will help to reduce that knowledge gap and ensure that everyone coming into government knows exactly what they're to do. So I favor, and in my own constituency, I get really excited when constituents express a view on a matter before the parliament, and on the occasions that I have had meetings with constituents about what is happening. I did that with the Road Traffic Act. They were so excited, and valuable and useful perspectives were shared. You know, I lean towards an approach which says that if you're going to take decisions that impact the lives of people, it's a good thing to get their input. It doesn't mean that your decision-making power is taken away from you. But if we're going to move to the place where the people take ownership of the rules and commit to abide by them for a more peaceful and orderly society, that's the kind of work that will have to be done by everyone in officialdom. That's why in the Ministry of Legal and Constitutional Affairs, we're closing the distance between officialdom and the people. You know, the community hop initiative, going in the markets, going in the streets, going in the towns, talking to the people about the work, reducing the space. So the goals can be achieved in other forms.
I think, though, that the primary point that is being made is for that engagement to be done prior to the drafting of the bill, so that that input, that public comment would be considered during that exercise. And then when it comes to the parliament, you'd already have thought through what people had indicated.
So, Madam Director, Legal Reform, you should be able to tell them that what we currently have does not preclude that, because it's just that there's no, the kind of discipline is yet to be cultivated around how we do it. So people get a chance to comment on policies when green papers are tabled. But we have to move now to ensure that once a green paper is a draft of a policy, what you're proposing. We have to get to the stage where the green papers are debated in the parliament. And that in the debate in the parliament, the parliamentarians actually go to their constituents and discuss the draft, the green papers, before it becomes settled and converted into a white paper as the policy of government. But right now, on many matters, you have stakeholder consultation, and proposed policies for legislation are circulated among critical stakeholders. Even draft bills are circulated in a restricted way because there are rules around them, and the rules make sense. Some of the rules can be revised. And we also know that even matters that are to go before the cabinet, those matters are sometimes circulated for input by the people. What we need is a lot more forward planning, but the system also has a place for that. That's why you have your legislative priorities being disclosed at the opening of a parliament at the start of the legislative year. What I'm looking forward to, is a calendar for the parliament for the year so that you know what is coming when it is coming. I'm also hoping that the standing orders provide for parliament to sit not only on Tuesdays but on other days. I've always been in favor of a schedule which has the parliament sitting for 2 weeks in the month, and the other 2 weeks members of parliament are allowed to go out in their constituencies. Those who hold ministerial positions can focus on them, and we strike a better time allocation between among the various functions of the different roles. So we can schedule our bills, we can schedule our motions, we can schedule our committees, but we also need a new parliament for that, where they're separate chambers. But we have ingredients of all of that the administration has put forward and that we're working towards. So there is so much to hope for, so much to come.
Perhaps a way of facilitating that proposal would be for a joint select committee or a select committee to be appointed at the time that the green paper is being put to the parliament. So not wait for the bill, but green paper or white paper, and then the public discourse could take place around that. That may assist.
Well, we can look at that. It need not be put in the Constitution. It can be put in the regulations to the Constitution called the standing orders.
Yes, definitely.
On the procedure on bills.
It doesn't have to.
Right.
I agree. It doesn't have to.
But I get it that the suggestion is geared at having a more informed participation by the people.
Ahead of
yes,
the draft of the bill.
Yes.
There is actually another recommendation. It is recommended to amend section 4910 and add subsection C to read, where an alteration is being made, there must be a clear written statement on the legislative intent for the alteration. A bill amending subsections 1A, 2, or 3 may not include provisions other than the stated constitutional amendments and matters connected with the amendments. I'm not sure what missed you.
I'll spend a little time looking on the recommendations from the groups on this matter, but just to say that we do not dictate how a provision is to be interpreted. What we do is to draft the provision in clear and unambiguous terms that would allow you to interpret firstly using the ordinary grammatical meaning of the words, and then using any of the other many aids to construing a statutory instrument. And the Parliament's role is not necessarily to interpret the law. That role is given to the judiciary. So the Parliament is to ensure that whatever it intends is clearly and unequivocally communicated in the words it uses in each provision of a bill. All right? So even this, I think, we have to educate the public on. And I note with curiosity that submissions are coming from places where they regularly engage the public, and the more closely I listen is the more closely I realize that a lot of inaccuracies and misunderstanding get communicated persuasively to the public, and then people hang on to things. So, we really have our work cut out for us to guide understanding of law. But that's why we say that you go through a training to read for the law. But I favor anything that will move us to a place where the people take ownership of the laws and the policies and also comply with them, because the benefits of compliance are clear.
So the Jamaica Bar Association,
Yeah.
the proposed Section 49 is different from the current Constitution in that, one, in respect of constitutional provisions that are neither entrenched nor deeply entrenched under a new subsection, subsection 1A provides for a 14-day waiting period between the introduction and debate of a bill proposing to amend non-entrenched constitutional provision, and between the debate and the passage of the bill in the House of Representatives. The Constitution provides no such waiting period. JAMPAR welcomes this amendment as it allows for a more considered review in relation to constitutional amendments of sections which are not entrenched. This is important as the Constitution is a governing document that outlines and facilitates the various functional arms of democracy and prescribes the relationship and nature of their operation. The executive, the legislature, and the judiciary. Okay. JAMBAR, however, considers that the 14-day time period is short and does not provide enough consideration for the review in recognition of the importance of a constitutional amendment. JAMBAR proposes that the period be extended to 1 month. Concerning the provisions entrenched under subsection 2 of section 49 of the current Constitution, the same provisions are entrenched on the proposed section 49(2). However, the waiting period between the introduction and debate of such a bill and between debate and passage of the bill in the House of Representatives under subsection 2 is decreased from 3 months to 2 months, decreasing the total period from 6 months to 4 months. JAMBAR does not object to this proposed amendment. It is noted that the entrenched provisions are maintained, and the decrease in the total waiting period from 6 months to 4 months is not such that the considered review of amendments to entrenched provisions is jeopardized. It is still possible for mature consideration to be given to the amendment under review, notwithstanding the decrease in the waiting period. However, the proposed subsection 2 contains a drafting error that needs to be corrected. As written, the clause providing for the waiting period between the introduction and debate of a bill amending the section provisions of the Constitution in subsection 2 of 49 and between the debate and passage of such bill is associated with subsection 2B only. Therefore, the waiting period appears to not apply to subsection 2A. However, intuitively and logically, it applies to both subsection 2A and B. To avoid any ambiguity, this clause should therefore be positioned below A and B of subsection 2, so that it ostensibly appears to apply to both 2A and B. Further refinement of subsection 2 is needed for clarity. The said clause providing for the waiting period between the introduction and debate and between debate and passage of a bill under subsection 2 should read, a bill for an act of parliament under this subsection shall, and the ellipses, or there's a break, or a bill for an act of parliament under subsection 2 shall, instead of a bill for an act of parliament under this section, shall. So I wonder if that was clear.
I can't help but chuckle on the saying which says you give an inch and they take a mile. So I'm pleased that everyone is becoming excited about a wait period for the amendment of any provision of the Constitution. In the same way that the provisions are given varying levels of protection, so the process is varied. The aim is to prevent a rush and to ensure that the matters can be considered, but at the same time, we want to be efficient. We'll further consider it because I do believe that we'll have to try to do some further restructuring of the provision and the thinking through.
Okay, so they're proposing that introductory words for subsection 2. As it is now, it says, insofar as it alters, and then it concludes. As written, it seems to apply to the whole section 49 and not just subsection 2. So the proposal is that it should make it clear that the bill should be a bill pertaining to subsection 2. That is something I would expect that the drafter would have to provide guidance on, Chair.
Yes, it's a printing error. The words that appear in paragraph B after the words paragraph A should go back to the margin. It wasn't drafted that way, so it's a printing error.
You mean a bill for an act of parliament under this section shall not be presented?
Yes.
Oh, but we dealt with that a long time ago. We dealt with that previously in the committee. I have a note of it.
Okay.
Yes.
Okay, well, that responds to that.
Right, so what the CPC is saying, we had identified that at the time when the bill was read through. Remember we read through every provision of the bill? From that time, it was indicated that there was a printing error and the words after the comma, after A, would go back to the margin. Yes.
On the matter of the deeply entrenched provisions under section 49.3, the provisions are the same under the proposed section 49.3. The mechanism of entrenchment remains the same in that the subsection provides for a waiting period between the introduction and debate and between debate and passage of a bill under subsection 3 in the House of Representatives and in 2 to 6 months after the passage of the bill, submission to the electorate for a vote. However, the waiting period between the introduction and debate of such a bill and between the debate and passage of the bill in the House of Representatives under subsection 3 is decreased from 3 months to 2 months, decreasing the total period from 6 months to 4 months. Again, we have no objections. The entrenched provisions are maintained, and the decrease of the total waiting period from 6 months to 4 months is not such that the considered review of amendments of deeply entrenched provisions is jeopardized. The proposed subsection 4 of section 49 is essentially the same as section 49.4, in that it provides for a vote of the senators appointed by the PM and LO only. It is, however, different in that the Constitution provides for the vote of all senators. The proposed section 49 excludes the senators appointed, by the President in his sole discretion from the vote on a constitutional amendment under the proposed subsection 2 and 3 of the entrenched and deeply entrenched provisions of section 49. This exclusion, to some extent, negates the additional 3 senators from various sectors of the society, as mentioned in the proposed amendments. We, however, agree that only those appointed by the electorate should have a say concerning entrenched and deeply entrenched provisions. The proposed subsection 5 and 6 of section 49 are the same, save for the period of delay between the Senate's rejection of a bill amending entrenched and deeply entrenched provisions in subsections 2 and 3, relative to the bill's passing in the House of Representatives, is decreased if the relevant bill is passed by the House of Representatives twice in the manner provided in subsections 2 and 3 and 4, and having been sent to the Senate on the first occasion at least 4 months instead of 7 in the current Constitution, before the end of the session, and on the second occasion at least 1 month, same in the current Constitution, before the end of the session, is rejected by the Senate on each occasion or in 2 successive sessions, whether the same Parliament or not, in the manner prescribed by subsections 2 and 3 and 4, having been sent to the Senate in each of those sessions at least 1 month before the end of the session, the second occasion being at least 4 months instead of 6 months in the current Constitution, after the first occasion is rejected by the Senate in each of those sessions. That bill may, not less than 2 months, nor more than 6 months after its rejection by the Senate for the second time, be submitted to the electors qualified to vote for the election of members of the House of Representatives. JAMBAR does not object to this amendment for reasons expressed in points 2 and 3 above. That is the extent of the comments on
All right.
clause 22.
We will consider the submissions more carefully. The goal is to simplify the mechanism without compromising the rail guards, and it's not an easy section to go through. It's not easy to understand even among experts. So we have some time to look back on it. I think this is as far as we will go today. I think something has gone into my eyes. Not sure what is happening here. Is there any other business that we...
Before we go, Madam Chair.
Yes.
As you had expressed earlier, the different categories into which the various provisions under 49 fall. And I believe in the submissions from JAMBAR, they actually followed along the same line where they spoke about those that are not entrenched, deeply entrenched, and so forth.
Yes.
Would it be useful, I mean, and for the average reader of this, the bill, the Constitution, eventually have a marginal note that identifies which category the various sections fall in?
Yes.
The broad categories, because I think that's how it is set out here, right? Those that are not entrenched.
So the label that we use is not a label that is in the Constitution.
I appreciate that.
Right.
That was for ease of reading, I mean, sometimes persons go to the marginal notes to determine what it is that a particular section of the legislation is dealing with. You appreciate what I'm inquiring about?
Please repeat for me.
All right. So,
Senator
for
Singh.
example, you have, if I were to look at where we have clause 22, and it says alteration of this constitution.
Yes. Clause
So,
22 is addressing section 49
that is
of
correct.
the Constitution, which deals with the alteration mechanism.
That is correct. But you have the note that says alteration of this constitution.
Yes.
Right. And then it categorizes the different sections of the constitution, which would require different periods depending on whether they were not entrenched, deeply entrenched, and so forth. That's how you categorized it.
Yes.
And I believe Jambar also did that in their submission.
Right.
For the average reader, because when we make would it be useful? I'm just asking if putting a marginal note so a person knows that this is how they are, the categories that one is dealing with, non-entrenched, or any other appropriate language. Just in the same way, like how you have alteration of this constitution as a marginal note.
Got you. I'll ask the CPC to answer. My understanding is that the marginal notes are aids, well, Madam CPC, you may respond. They usually go for the section. But
well, I'm a little unclear. Is that asked for marginal notes for 49 itself to be broken down?
Yes.
In subsections to indicate what level of entrenchment is being dealt with?
Yeah.
Oh, well, yes, I would make the same remarks as Madam Chair that the terms that we've been using are not really forensic because they are not used in the Constitution itself. And so it could perhaps create some contradiction if we were then to use that language that we've been using colloquially.
And I'm saying any other appropriate language. It is just to make things a bit more, create easier reading for the average person who may take it up and be looking through and trying to appreciate.
I understand.
Why is this one required?
I understand your point, Senator Sinclair. Without prejudice to any decision or recommendation on the matter, bear in mind that when it comes to altering the Constitution, it's not something that the layman would altering the Constitution or altering Section 49 itself would be doing. And so while we are moving in the direction of simplifying as much as possible things for the layman, there are some things that require a specific role and a specific understanding. It's not meant to operate by just the man in the street picking it up.
It's about the person taking it up and
I understand. No, that's what I'm saying.
Understanding what is contained in his constitution.
I understand your point. So what we are moving towards is explanatory notes for our laws.
Yes.
And we will start in a serious way with the Constitution. We have to get there. But without prejudice, I'd leave that to the drafter to see how, if at all, it can be accommodated. But I note the general point is that as far as possible, we should help those who are reading the law to navigate the passages. take the point. All right? We have, let me see very quickly. So that's 49. So the decision of the committee, from what our discussion, is that we would take another look at 49 to see how we can simplify the structure without compromising. 40, 22, then we go to 20. We have nothing on 23. We have no submissions on 23. So we have 24. All right, maybe we can do 24 before we adjourn. This suggests the submissions on clause 24. Amendment of section 58. Page 58 of the matrix.
Amendment of section 58 of the Constitution. The ministry, this is the Ministry of National Security. The ministry wishes to highlight that dissent is defined differently under section 24(3) in relation to the citizenship qualifications for president. In quotes, for the purposes of paragraph 2A, by descent means by virtue of having a parent or grandparent who is a citizen of Jamaica by birth, unquote. The definition here limits the application of descent to a grandparent. Why was this approach not utilized as the definition through the amendment?
Because we have different, the provision, the citizenship relates to different things in different sections of the Constitution. That's a simple answer.
Chair?
Yes.
I believe that submission should be placed elsewhere because clause 24 amends 58 to remove the words if practicable. It doesn't speak to citizenship.
I wondered about it when I looked also.
I believe that should be placed elsewhere.
Yes. Noted. Thank you. Okay. 26. Well, we are almost through with the matrix, so we probably should just try to finish it, and then we can come back to anything additional. So let's go to 26. Yes.
Section 26, repeal and replacement of section 60 of the Constitution. Sorry, clause 26. Jamaicans for Justice, recommendation 1. It is being proposed to amend section 60, subsection 3 to read, If the President does not signify assent following the expiration of 30 days after a bill is presented for assent under subsection 1, the Speaker shall signify assent. Doesn't it say that now?
So they're saying that you insert a time frame if the assent is withheld or is not.
Rather than within 30 days, they're proposing that it read following the expiration of 30 days.
Well, the assent is the last legislative step for the enactment. This is separate and apart from bringing the law into operation.
Publication in the Gazette is the last step.
Sorry?
Publication in the Gazette after assent.
Well, parliamentary, the parliamentary step that I mean, parliamentary step, because the Governor General is a representative of the monarch who is also a part of the Parliament, and that's the legislative role of the monarch, of the head of state. I don't have a hard or fast view on the matter. What we want to ensure is that if there are any issues and doubts, those things are properly communicated. We already have a process. I think people are confusing a pronouncement by the court on the unconstitutionality of a bill and not understanding the presumption of constitutionality once the bill is passed. I think those are, I'm surmising, are issues of concern. So you can have a preemptive challenge. How the court rules on it is whether what is before it is enough, is sufficient to enable it to say that any alleged unconstitutionality is made out. And I have seen mixed, I've seen decisions of the court that I don't agree with at all and which have been subsequently overturned at higher levels on appeal. I think because we have had such contentions in the past, people don't understand that there is a presumption of constitutionality, that there is a process by which you check for constitutional compliance, and that is without prejudice to a court reviewing it and coming to a different conclusion. It is expected, though, that in the process, the considerations taken into account would be presented before the court. But you bear in mind, too, that sometimes when you are doing the assessment for constitutionality, you do not have contrary views and arguments being presented. So it's not the same as a contested view of the matter. But as far as possible, great care is taken to ensure that the Constitution is complied with.
May I inquire, Madam Chair? I'm reading the bill and looking at what the original...
Senator Sinclair, look on your screen and tell us what comes
Are you hearing me?
Yes, but you may need to just adjust your screen so that we don't see your head cut off on the television.
Because I'm looking down that. All right, so... And I wouldn't want to have my head cut off. All right, section, the clause 60.
Yes.
Which is, well, 26,
60, yes.
Which is proposing to amend 60.
Yes.
So when you look on 61, 60, subsection 1, which reads, a bill shall not become law until the President has assented thereto and signed it in token of such assent. And the President shall, on being presented with a bill or assent in accordance with this Constitution, so signify assent. That's what the proposed 60 is. So the use of the word shall would seem that the President is mandated to do so. once the bill is presented to him or her. But then you have 3. If the president does not signify assent within 30 days after a bill is presented for assent, then the speaker shall signify assent. What would create a situation that what is proposed in 60 not apply, where it is mandatory for the president to assent?
I have to give you some background. All right.
Okay.
The
Well, not me alone, but everybody.
Yes.
Meaning
So currently, we know that the parliament is tripartite. It comprises the monarch, a Senate, and a House of Representatives. And each of the 3 parts has a legislative role. All right? When the bills are passed, there are some matters. All primary acts of parliament are passed by both houses. There are some subsidiary legislation that can be done by the House only, depending on what is said and provided for in the primary legislation. But as a general rule, the legislative function moves across the 2 houses of parliament, and then the legislative role of the head of state is to signify assent in token. No veto is given to the non-executive head in legislative affairs. So the legislative function is a very limited function, and it is a formality. At one point, we had proposed that going forward, the parliament would be separated entirely from the executive. But the Constitution is a well thought out, interwoven machinery. And because we were not doing the full review of it all at once by virtue of just the magnitude of the work, we decided to err on the side of caution and did not implement a recommendation which takes out the head of state from the parliament, because we had so many other things that were predicated on the head of state being part of the parliament. So right now, what the proposal is for is to retain the legislative role to signify assent, but that to make it clear that there is no power to veto it. And if the law has been passed by both houses, if it has been reviewed and the certificate of constitutionality is issued, that the signifying of assent is to be done. And we do not wish to have laws being held up because there is uncertainty as to whether a head of state wants to signify that assent. So this is what it is intended to do. We have in other jurisdictions where, I think, was it a Grenada or one of those other jurisdictions? I can't now recall. But another jurisdiction where we had seen the problem arise. So it's really maintaining what the legislative role of the head of state is, that would then be in the office of president, and that, if that is not done, then it comes back to the Speaker of the House to signify that assent, so the bill can then be gazetted and we move to bringing it into operation. That's really what it is.
Yes, but I'm just trying to understand. If a president is, the duty function of the president is stated that you shall do a particular act if a bill comes to you after going through due process.
We have had examples, Senator Sinclair.
That the president would not?
We have had examples. Just let's say that if you compel someone to do something, then you also have to consider what happens if that person fails to do it. I mean, it may raise other issues about whether the person continues to hold office. and so on, and so on, those other kind of issues. So we're not going into those other issues, but broadly speaking, that if you compel action, then you also have to find a way to ensure that if there is omission and the action to be taken is important, that it can be carried out in the face of omission.
Okay. I will accept your position as you have stated without going into the other things, because I was quite interested to understand what the other things would have been.
But for this purpose, yes.
Yeah,
I can see where, and those other things, of course, would be important to other things.
Okay.
Yes. All right. Can proceed.
Yes.
It is recommended to add section 64 and 65. They should read as follows. If the President has reservations about the constitutionality of a bill, with the exception of money bills, he may, in his discretion, once refer that recommendation back for reconsideration by the House. A, the standing orders of the House of Representatives and the Senate shall provide for the procedure for the reconsideration of a bill by the House. Where a bill is sent for reconsideration under subsection 4, the President may return the bill to the Houses with a message. The message may request the Houses to reconsider the bill or any specified provisions, and in particular, to consider the desirability of introducing any amendments recommended by the President. The House of Representatives must participate in the reconsideration of a bill that the President has referred back to the House if, 1, the President's reservations about the constitutionality of the bill relate to a procedural matter, or Section 7, 49, 56, and 57 was applicable in the passing of the bill. D, if after reconsideration, a bill fully accommodates the President's reservations, the President must assent and sign the bill. If not, the President must either assent to or sign the bill or refer it to the Constitutional Court for a declaration on its constitutionality. The President may refer any bill, except money bills, to the Supreme Court for a decision on the question as to whether such bill or any specified provision or provisions of such bill is or are inconsistent with this Constitution or to any provision therein. Every referral under subsection 5 shall be made no later than 7 days after the date on which such bill was presented to the President for assent. The President shall not assent to any bill the subject of a reference, I wonder if the word is missing, to the Supreme Court under this section until the pronouncement of the decision of the court. Oh, he has to wait for the court's decision. The Supreme Court, consisting of not less than 3 judges, shall consider every question referred to it by the President under this provision for a decision, and having heard arguments by or on behalf of the Attorney General and by counsel assigned by the court, shall pronounce its decision on such question in open court as soon as may be, and in any case not later than 60 days after the date of such reference. The decision of the majority of the judges of the Supreme Court shall, for the purposes of this section, be the decision of the court and shall be pronounced by such one of those judges as the court shall direct. If the Supreme Court decides that any provision of a bill, the subject of a reference to the Supreme Court under this provision, is incompatible with the Constitution, with this Constitution, or to any provision thereof, a declaration of incompatibility shall be made. This declaration is not binding on the parties to the proceedings in which it is made. In matters where the Supreme Court makes a declaration of incompatibility, the bill shall be referred back to the House of Representatives. The Houses of Parliament shall decide whether to proceed with the bill in its original form or whether to make amendments. If Parliament makes amendments based on the declaration by the court, the President must assent to and sign the bill. If the President does not signify assent within 30 days after a bill under subsection 6, the Speaker shall signify assent. In every other case, the President shall sign the bill within 30 days after the date on which the decision of the Supreme Court shall have been pronounced. And that is the only comment on that clause.
Well, I'm thinking that sometimes things sound really good and really convoluted, but we don't think about how we administer them in real time. So all offices in government are supposed to be supported by professionals. The office of the head of state should have at its disposal support staff. I think because, well, I was wondering if because we have had in recent memory so many allegations and cross-allegations of constitutionality and threats of it, we have more cases that go to court on constitutional matters ending favorably to government than we have cases ending unfavorably. But in recent times, a lot of the issues have arisen in a political context where sometimes there are genuine differences and other times, from what I'm observing, it's just outright stark partisan competitive issues. And it is not the intention that in government you are going to be challenging your work in the way that I think is coming out in the proposal. You want input to ensure that what is done is thoughtfully done and that it is reviewed for compliance. So it's almost like insiders' privilege and outsiders. If you're inside and part of a process, you can take advantage of opportunities to make your contribution along the way. Right? It's a different thing now when you're not on the inside. You don't have an opportunity to do so until matters become public. That's why sometimes you don't hear colleagues criticizing each other on the same side. They may have the same concerns that are raised, but as an insider of a group, you have an opportunity to say to your colleague, I take issue with this, and you can resolve it. When you don't have that opportunity, invariably you may raise your concern publicly. So in the lawmaking process, I don't want anyone to think that because a court may ultimately rule that a matter is unconstitutional after hearing arguments means that the matter was not carefully considered at all by the Parliament. There's a different role for everyone. So a law does not get to the Governor General currently for signing without going through a process. And when the law is passed by both houses, it goes to the Attorney General's chambers, staffed by experts, you know. Remember that everybody think that they are an expert in the law because they may be able to talk a good talk, but you really have to go through training. And even after you go through training, that still don't make you an expert, especially in constitutional law or legislative law or public law. So I would say to JFJ that you have to give space for the offices to work well. I'm hearing the suggestion, and I kind of can see what excites you to propose it, but that's not what we want the legislative process to be like. We don't want a law that has not been properly considered to pass either. But it's not the head of state that is going to now take on the role of being the opposer to the law when you have a part of the legislative function to exercise. Right? So I understand what you're kind of saying, but it's a wrong context. That's my preliminary view on the matter.
Just, Chair, I think it is speaking to the concern voiced many times in the public sphere that the president ought to be someone with a role that is not that it is sent to you, you are sent, and that's it. I think they're trying to provide
but
for...
But that's not how it goes, you know. It's not just that it is sent mindlessly. A certificate follows it. Work is actually done.
The certificate is coming from the Attorney General, who is part of the administration of government.
Hold on.
So,
pause right
no,
here.
I'm only reflecting what has been said in the public domain.
But people walk down a path and thinking that because you're part of government, you don't bring professional standards to bear in doing your job. We don't ever want to even give credence to that, even though we have examples of it. And that's not how things are supposed to go. The law has objective standards, you know. You don't make up the laws, you go along. That's why a rule of law requires public promulgation of laws. You don't make it up as you go along. And to pass laws, you actually go through a process. And then the other side is equal application, and then impartial adjudication. So a lot of proposals are premised on some views that come out of genuine concerns, but it's proposing something that when you stop and break it down, you need to rethink it. So a view has been put out because people disagree that an attorney general is just going with the flow. The attorney general's role is a very specific role. But even though an attorney general is politically aligned, that does not mean that the Attorney General does not consider the matters properly as an attorney at law. I recall being told by, you know, let me not call the name, but just to say that when I was in the role of Attorney General, that because I am a member of the Parliament, my advice would be suspect. So I had to ask if the previous Attorney General, who was a member of the other side in the Parliament, if his views were suspect also by virtue of that fact. Because if you're going to talk to me in principle, the principle must apply across the board. And then you realize that the cloak was lifted because it was not a principled position. The Attorney General is not any creature. That's why you have below the Office of Attorney General a cadre of professional staff headed by the Solicitor General, which is not meant to be political either. But what is wrong with being political? It does not mean in an appropriate case that you're devoid of sense.
I don't think that if I remember what reading
comments,
I don't think that's where it was coming from, you know. It's just that if you're going to have this individual have a role, then that individual's role should be more than just I assent. I think that was the thinking. Not casting aspersions on the Attorney General, but rather, can this person's role be a little bit more than just I assent. I think that's
I
what
understand
it was.
that, but there also has to be an understanding of how a non-executive head of state functions.
Well, yes.
I think if there is greater understanding of that, because more and more they're calling for executive functions
That's it.
to be vested, and that is where the struggle is now.
Yes.
Do we stay parliamentary system? Do we
That's the
go
point.
executive presidential system? That's
Yes. So that is where this
you have
is
to
coming
unmask it. You have to be able to unmask it. It's a real struggle, and I'm not bringing up value judgment on it, because there are features of the executive presidential system that are good. But when we have a system that we have not truly seen its strength demonstrated in recent times. But the research that we have done shows that certainly for Jamaica, the parliamentary cabinet system would be a better system. But we also know that systems are driven by system drivers. And sometimes when the system drivers are driving recklessly and carelessly, are not driving at all, instead of calling them into question, you start questioning the system. We can disaggregate appropriately, and then we mash up a good system because we know system drivers need, a different approach. All right, let's. But just to say that it is always something to consider. What is the extent of the legislative role? Right now, I can just simply answer it by saying it is not meant to give a veto to a non-executive president. Right?
Cool. Clause 27, amendment.
Before, excuse me. I was just reading through the original 60.
Yes.
And listening to the discussion that you had a while ago, Madam Chair.
Yes.
And also rereading the proposed 60 in the bill. And although the wordings are different, they may actually be coming out almost to be saying the same thing, because in the existing 60 subsection 3, it says that the Governor General may give assent, or he may withhold his assent, right? That's in the original 60 subsection 3. Right. When a bill is presented to the Governor General for assent, he shall signify that he assents or that he withholds assent. Right. Okay. In the proposed 60, when I was looking at it again, in 60 subsection 1, it says that the President shall, on being presented with a bill for assent in accordance with this constitution, well, I don't know if the bill, the in accordance with, is referring to a procedure, or it is relating to, for him to determine whether does this meet the requirements of the Constitution. Probably that is why you have in the proposed that if the President does not signify assent within a certain period of time, because I just wondering how one provision was saying it is mandatory for him to assent, which seems to be that you are rubber stamping something, or he may be of the view, well, I'm not giving assent to this because I may view that it is not in accordance with the Constitution.
I think it's not so much rubber stamping, but it was a token. It's in token of it. So it is expected that the legislative work be done by the houses, the two houses of the Parliament. Right. That's really what it is. So if you frame it, as rubber stamping, it may take you down one rabbit hole. But if you're understanding that it's really just a token of it. Yeah. So the real question is it necessary to have that token role? And like I said, we were going there, but out of an abundance of caution, just to ensure that until we do the complete revision, we just not miss anything. So we keep it as is, but clarify that it is not meant to provide a veto, and instead we would focus on ensuring that the House side of it is done carefully. All right.
Then I've got a little worry in my mind, but anyhow.
Tell me what the worry is.
I'm still just trying to then appreciate in what context or in what circumstance could a president decide that he will not signify assent for the provision to be stated there. In what situation?
I can think of many, but
you don't want to
it would be yes, trespassing. You know, Senator Sinclair, I once went to court in my role as Attorney General. I'm just telling you by analogy. And you know what I was told to the court? Well, we have our own dispute with the government too, in the matter that was before the court. And I immediately said, but hold on. If the bench is saying that it has its own issue with the government on the matter before it, is it still an impartial arbiter? Some of these things will have to be written. Seriously. We have our own contention too. So if you become an aggrieved party on a subject that is before the court, can you retain your impartiality on the matter?
All right, let me ask you, Madam Chair. Yes. The existing 60 that says that the 63, the Governor General may withhold his assent. I notice that there's nothing else that follows. What would happen in the current situation?
I think we have an example where assent was withheld? I think
just asking.
Yes, I believe so. Nothing happened. It just languished or it came back. But usually it would require some discussion. So I know, for example, that since I have been in the Parliament, you know, questions have been raised which required just a better understanding by the Governor General of matters before the Parliament. And nothing is wrong with that at all, you know. But what needs to be clear is that it is not intended that the executive would have a veto on legislative matters, even where we retain the executive as a part of the Parliament until such time when it may change in so far as that function. So right now, the legislative function is primarily within the two houses of Parliament, going through the lawmaking process. But it does raise a proper question. Do you then retain it? Like I say, we're just erring on the side of caution at this time.
No, the provision that is being proposed brings a finality to it because it goes back to the Speaker.
Right.
After 30 days, shall signify assent.
Right.
And so if there is an issue that one has, once you get to that stage, then persons can go to a constitutional court.
Right.
For the determination.
Right. Yes.
So that's what I like about it. But I'm just trying to.
But you don't need to set it out in the Constitution to say that you can go to the Constitution Court. We already know that.
No, I appreciate it. You don't need to set it out
exactly.
there. Yes,
exactly.
Yes. But can I, since you said it has happened on one occasion, and for my own edification, what happened?
Ago, you know, yes.
Under the.
So let me just put in my caveat if my recollection is correct, because I did inquire and that's what I was told.
Okay.
Yeah.
And were you told as to what occurred in
I
that
think it
situation?
didn't proceed.
It was
Right.
just left.
Yes.
Well, it would be an improvement, as I said, because it brings
Right.
to a finality a particular process. And if persons have a concern, then they can go elsewhere to have that concern addressed with the proposal where the speaker shall signify assent. So in that regard, I do regard it as an improvement on what currently exists.
That's what we thought too.
Yes.
Yes.
So I was just wondering, as I started out, in one provision it was mandatory, and then it came back to a situation where in 3 it would appear that it is not, and he can. But if he doesn't, then there is a final position that can be taken in moving the legislation forward, which I believe is an improvement on the existing 60. So,
right.
Yeah.
Certainly,
thank you.
in the interim, yes. All right, thank you, Senator Sinclair. We have 2 other clauses, 27 and 20.
35. There's more than, well, yes. 31, 30. They're actually 67A, 30, 31, 35, and then the memorandum of objects and reasons. So it's actually about three provisions.
Go ahead. I was just looking on the suggestion to replace the ackee with the mango. All right, proceed.
Clause 27, amendment to section 64, recommendation from Equality for All Foundation. We object to any proposal that expands the grounds on which Parliament can be extended, as is imagined with inclusion of section 20, which would allow the life of Parliament to be extended under a state of public emergency, which is generally used to fight crime. It also lowers the voting threshold by only requiring 2/3 majority of the lower house. That is it.
Well, just to be clear, we have experienced a pandemic that we never thought would have happened in our lifetime. And when the Constitution was amended in 2011 to insert the new charter, and the concept of a state of public disaster was introduced, the provisions fell short of just carrying through the arrangements in respect of public disaster. So it's important that everyone understands that there is a difference between the public emergency and the public disaster in Section 20, but the provisions have not been fully fleshed out. So the reason for only referring it to the House of Representatives is that the Senate is not elected, and the extension of the life of Parliament has to do with when elections are held. So the logic is clear, and just so we can also clearly communicate it. The Senate is not elected in our system, so they don't have anything to do with the election of it. And it's not about extending the life of Parliament to carry on generally. It's in very, very specific circumstances. And the extension time proposed is limited, and is truly to prevent any constitutional crisis. It makes no sense that things are reasonably foreseeable and we don't plan for them. This is not about trying to hold over power or anything like that, but it's recognizing that things can happen, and when they do happen, we have to respond to them. All right, so that's by way of explanation, so that it can be clear, and just to answer the question.
Okay, the Jamaica Bar Association. Section 64 addresses the prorogation and dissolution of Parliament. Under subsection 2, the duration of Parliament is set at 5 years, with the possibility of an extension during wartime, as outlined in subsection 3. Subsection 3 allows Parliament to extend the 5-year term by up to 12 months at a time during any period in which Jamaica is at war. However, the total extension period cannot exceed 2 years. Clause 27 of the bill proposes an amendment to Section 64 by introducing another subsection, subsection 3A, by making the 5-year period prescribed in subsection 2 subject to subsection 3 and 3A. The added subsection 3A stipulates an additional condition under which the life of Parliament may be extended beyond 5 years. Specifically, subsection 3A allows Parliament to extend its 5-year term by up to 6 months via a House of Representatives resolution during a public disaster declared by the President under Section 20 of the current Constitution. This 6-month extension can be renewed for an additional 6-month period, for additional 6-month periods, provided that the overall extension does not exceed 2 years in total. We have no objections to this amendment, as we believe it is appropriate to extend Parliament's duration during a public disaster to ensure continued governance in the interest of public safety. Additionally, we support retaining the constitutional safeguard that limits any extension to a maximum of 2 years. This measure is important to prevent potential abuse of power by any government. Those are the comments on that clause.
It appears that the Jambar understands what we're seeking to do in context.
Indicating concurrence.
Right. All right.
New section 67A, part 5, Electoral Commission. The Equality for All Foundation, their recommendations are, the following are being proposed. The EFAF welcomes the enshrinement of the Electoral Commission of Jamaica in the Constitution. However, it is submitted the selection process for the commissioners be included as part of this constitutional enshrinement. Jamaicans for Justice. The following recommendations relate to Electoral Commission. 1. Safeguard the independence of this ECJ. In the exercise of its powers and performance of its functions under this Act, the Commission, A, should not be subject to the direction or control of any person or authority other than the Supreme Court by way of judicial review. B, shall act independently, impartially, fairly, and in the public interest. And C, shall have the power to do all things as it considers necessary or expedient for the purpose of carrying out its functions. It's strengthening the functions of the ECJ as it is given entrenchment. It is being recommended to amend Section 67A to strengthen the process for amending electoral districts. Include 67A3. Review the number of constituencies and boundaries thereof and make such recommendations to the Standing Committee of Parliament as are appropriate as provided for in Section 67. The following amendments are suggested for Section 67. 1. Amend 67.6 to include all reports shall consider the opinions and recommendations of the Electoral Commission of Jamaica. Amend 67.10. If any draft made under this section is approved by a resolution carried by 2/3 majority agreement of the House, the minister shall submit it to the President, who shall make an order which shall be published in the Gazette in terms of the draft, and that order shall come into force on such day as may be specified therein, and until revoked by a further order made by the President in accordance with the provisions of this section, it shall have the force of law, provided that the coming into force of any such order shall not affect any election to the House of Representatives until a proclamation is made by the President appointing the date for the holding of a general election of members to the House of Representatives, or affect the constitution of the House of Representatives until the dissolution of the Parliament then in being.
I think we are struggling with what independence mean and where is the right place to account for things. I know that there are genuine concerns about how the Parliament operates, but I've seen along the way where powers are stripped and we don't get the kind of improvement. We have to insist that when functions are set out and powers are granted, that they be performed and there be accountability for the performance. So, you know, somebody has to account to something. And really in a democracy where we claim that the people is supreme, you go through a process and you elect their representatives. What we want to do is to make sure the representatives can account in a good way. And that remains work in progress. Work in progress. The reports, any report from the ECJ is considered, is usually considered, and in fact is more than considered. There is a convention that on some matters, the recommendations of the ECJ are in fact implemented. But it is also important to note that when primary function is vested in one entity, one body, or one office, the fact that you may delegate it does not preclude you from exercising those functions. The model of the ECJ has worked relatively well, and I think the strength of it lies in how it is constituted, with the political parties being represented and then persons independently of the political process. So I hear the recommendation that the process for selecting the commissioners be included as something to consider. And in respect of strengthening it, again, when a part of the Constitution is under consideration and we have before our very eyes how those provisions work or can be manipulated, it gives us cause for pause. And I note that sometimes the examples are distant and sometimes they are very near to us. I think the quarrel around the sequence in which the Portmore issue is taken, I can see features of it around boundaries happening here. I think we'll have to spend a little time just enlightening and educating, using that Portmore issue as an example, so there can be no misunderstanding, because sometimes people take the contention of one side and run with it as if it represents the law and the state of affairs. So who has the power to do what? In what sequence is it to be done? Does the exercise of it in one place means that it is improper, even if you desire it to be other ways? And we also have to get those who are working the system to understand that if you're sequencing, options for sequencing can be better or worse. But we mustn't kind of conflate up all of the issues. All right, I think the last section has
Clause
to do
29.
with the...
Section 60. Executive authority.
Yes? Yes?
Okay.
We would like
The
serious
repeal
consideration.
and replacement of section 68. This is Jamaica lands. We would like serious consideration to be given to revisiting the relationship between the Parliament and the Cabinet.
Understood. Lands will be consistent with that because nothing short of an executive presidential system will suffice for it. The parliamentary system is not, the parliamentary system has the political executive drawn from the legislature, and it's designed for a certain kind of accountability that is work in progress. Yes?
That is the...
Well, I note just the
Only
last
comment.
set is that the Jambar is saying that there is no need to vest the intellectual property of the symbols in the Constitution. Existing laws amply protect the national emblems and guard against their misuse. And there is safeguard against arbitrary use of the national emblem. Those are they. Then the Rastafarian Unity Council is asking that we change lest we perish to
Let us prosper.
To let us prosper, and we change the ackee to the mango. I know the mango sweet and we don't drink coffee, tea, mango time. Care how nice it may be. Interesting suggestion.
Well, they're saying because of the high content of arsenic in the ackee.
Ah. But we know how to use it in a non-poisonous way. Well, the good thing about the symbols is that those are matters that can more easily be dealt with. And we really can have a proper discourse around the symbols. But what we're just doing is saying what we have now, and whatever those symbols are, they are to be in the highest law. We're not entrenching them, so we can always have conversations around them. All right, we will have to come back to the matrix in terms of the decisions we take, but I really want to thank everyone who has taken the time to make a submission. And don't take the interrogation of the submission to mean that we don't appreciate it at all. I am very grateful that you've taken the time, and I see varying levels of understanding reflected in the submissions, but I still appreciate them coming because it tells us that we still have a lot of work ahead of us. I see creative ideas, I've seen critical thinking, and you see not so critical thinking, but at the end of the day, there is something to learn from. All right, so it's 5:50. We're going to terminate the meeting unless there is any other business for us to deal with. The date and time. next Wednesday. Or, wait, let me just see. Proposing for the date of the next meeting, next Wednesday at 2, just because of schedule conflict in the morning. So that's the 14th. All right, we are making progress. We will, so I reiterate that we start preparing the report and draft, all right? Senator Sinclair, you
I'm here, ma'am.
want to move for the
So
termination
move.
of the
I move.
meeting? 5:53, and I am there with you. Right, thank you all.